Okay, students, welcome back. Students, and in this part of lecture, I'm going to deliver my lecture on the what is the history, what is the background, and overview of the International Court of Justice. And students, the feature of the students, the feature of the previous lecture in the introduction, what we have learned that ICJ, the principal judicial organ of the United Nations, which established in June 1945, and the seat of courts, uh, is a seat of the court, uh, Peace Palace in The Hague, the building which is the old architect was called Peace of Palace, which is located in Hague, Netherlands. The court's role is to settle in account with international law, legal disputes submitted to it by the state, and to give advisory opinion on legal questions referred to it by the authorized United Nations organs and specialized agencies. The composition of the 15 judges elected for a term of 9 years, and the official language of the International Court of Justice is the English and French, and and interestingly, the ICJ also called as the World Court. The history, the history of the International Court of Justice, precisely, it is the successor court of the Permanent Court of the International Justice (PCIJ). The Permanent Court of International Justice was created in 1922 and by the League of Nations. Between 1932 and 1940, it handled 60 cases. It was dissolved after World War II, and the ICJ succeeded the Permanent Court of on the 18th April 1946. It inherited not only its statute but also its jurisprudence and its traditions. And the idea for the creation of international court to arbitrate international dispute first arose during the various conferences that produced at the Hague Convention in the late 19th and the early 20th centuries. The body subsequently established the Permanent Court of Arbitration was the a precursor of the Permanent Court of the International Justice (PCIJ), which was established by the League of Nations earlier, which we have learned. And from the 1921 to 1939, the PCIJ issued more than 30 decisions, which the number are the 60 by some books suggest us, and delivered nearly as many as advisory opinions. All members of the United Nations are parties to the statute of the ICJ, and non-members may also become parties. The outbreak of war in September 1939 inevitably had serious consequences for the PCIJ, which had already for some years known a period of the diminished activity after its last public sitting on 4th December 1939. The Permanent Court of International Justice did not, in fact, deal with any judicial business, and no further elections of judges were held. In 1940, the court removed to Geneva, a single judge remaining at The Hague, together with a few registry officials of the Dutch nationality. It was inevitable that even under the stress of the war, some thought should be given to the future of the court as well as to the creation of a new international political order. In 1942, the United States, as Secretary of State and Foreign Secretary of the United Kingdom, declared themselves in favor of the establishment or re-establishment of an international court after the war. And the Inter-American Juridical Committee recommended the extension of the PCIJ's jurisdiction. So after the establishment of the World Court, that is the ICJ, then what will be the composition and formation of the formation of the ICJ. The composition of the ICJ, the court consists of 15 judges and they are elected for a term 9 years by the General Assembly and Security Council. 5 posts are renewed every 3 years and judges may be re-elected. Same judges can be re-elected and the members of the court must all be from the different countries. But we must keep in mind that they do not represent their country and they are independent judges. It means in the International Court of Justice, those judges are appointed independently by the UN and the Security Council. It doesn't mean those judges are those judges will be appointed for the representation of their countries, but they will be appointed as the independent judges. The composition of the court represents the following geographical balance. You can say the seats of judges are divided between these geographical balance. 3 seats on the bench are occupied by the African judges. 2 seats are occupied by the judges from the Latin America and the Caribbean. 3 are occupied by the Asian judges. 5 judges are occupied by the judges from the Western Europe and other Western states. 2 judges are from the Eastern Asia, and oftenly there's 1 judge from each of the countries who are permanent members. So there are permanent member of the United Nations, and these are the 5 permanent judges of the ICJ. And except from those 15 judges, there are also ad hoc judges can be appointed when a case is presented before the ICJ and a state party does not have a judge on the bench from their state. Then they can choose a judge known as the judge which ad hoc. These judges can be from any nationality and not necessarily have to be from the state party. They have the same rights and duties as an elected judge. The formation of the ICJ is we have discussed earlier. On the 13th October 1943, a joint declaration by China, United Kingdom, the USSR, and the US was issued to recognize the necessity of establishing at the earliest principle of the sovereign equality of all peace-loving states and open to all such states for the maintenance of international peace and security. Thereafter, on 9th October 1944, there was a publication of the proposals from the establishment of the General International Organization to include an International Court of Justice. The next step was to convening of a meeting in Washington in April 1945 of Committee of Jurists representing 44 states. This committee, under the chairmanship of Hackworth, United States, was entrusted with the preparation of draft statute for the future International Court of Justice for the submission the San Francisco Conference. The draft statute prepared by the committee was based on the statute of the PCIJ and was therefore not a completely fresh text. The committee nevertheless felt constrained to leave a number of the questions open which it felt should be decided by the conference. 50 states participated in the San Francisco Conference. The conference decided against compulsory jurisdiction and in favor of the creation of an entirely new court, which would be a principal organ of the United Nations on the same footing as a General Assembly, the Security Council, the Economic and Social Council, the Trusteeship Council, and Secretariat, and with the statute annexed to and forming part of the Charter. The Francisco conference therefore showed some concerns that all continuity with the past should not be broken, particularly as the statute of the PCIJ had itself been drawn up on the basis of the past experience. And it was felt better not to change something that had seemed to work well. The judges of the PCIJ are resigned on 31st January 1946, and the election of the first member of the International Court of Justice took place on the February 1946 at the first session of the United Nations General Assembly and Security Council in April 1946. The PCIJ was formally dissolved and the International Court of Justice meeting for the first time elected as its president, Judge Jose Gustavo, and thereafter the members of the court, which are the International Court of Justice, is composed of 15 judges elected to 9-year terms of office by the United Nations General Assembly and the Security Council. It may not include more than one judge of any nationality. It means only one judge of one nationality can represent in the ICJ. It can be re-elected, but those judges do not represent their countries, but they will be independent judges of the court. These organs vote simultaneously but separately in order to be elected. A candidate must receive an absolute majority of the votes in both bodies. This sometimes makes it necessary for a number of rounds of voting to be carried out. In order to ensure a measure of continuity, one-third of the court is elected every 3 years. Not every 5 years, but after every 3 years, 5 judges will be elected. Judges are eligible for re-election should a judge die or resign during his or her term of office. A special election is held as soon as possible to choose a judge to fill the unexpired part of the term. Elections are held in New York on the occasion of the annual autumn session of the General Assembly. The judges elected at a triennial election enter upon their term of office on 6th February of the following year, after which the court proceeds to elect by secret ballot a president and vice president to hold office for 3 years. All state parties to statute of the court have the right to propose candidates. So, students, it was the brief demonstration how ICJ formulated and how many members and how member judges elected in the ICJ. So thereafter, our next topic will be the election or nomination or so students, thank you very much for this session. And next, our topic, as I earlier said, regarding the president and vice president of the International Court of Justice.